Okay, good afternoon everyone. This will be my video lecture in legal aspects in the hospitality and tourism industry. Now today is Thursday afternoon. It is October 20, 2022, and I'd like to announce again as per disclosed during your uh, disclosed yesterday, no, through our GC group chat. I said there that your preliminary examination will be next week, no, October 27, 2022. But there is a change in the time, no? The time now will be from 10 o'clock in the morning until 12 noon time, no? I repeat, your preliminary examination will now be, still the date will be October 27, 2022, that is next Thursday, but there's been a change in the time, no? It's now 10 o'clock in the morning until 12 noon time, no? So be prepared for the preliminary examination, and I expect you to have viewed all my video lectures, and also you have done your assignments, because all of those will be included as the coverage, no? So today we are still on the topic on obligations and contracts, but we will finish or wrap up everything today. Okay, so we are through now. After my lecture for today, we are through with the topic on obligations and contracts. But before I proceed to my new topic, which is vices of consent as well as defective contracts, I will take you to a short review first. What are the three essential requisites? Three essential requisites of a contract again. Requisites of a contract. Okay, what are they again? Okay, we have first consent, then we have object certain, and then of course the cause. No? Remember this, no? COC, assure code. Now consent, we talk about this because the topic for today about vices of consent. Vices of consent has something to do with this, no? This one, no? And we said that when you are entering into a contract, of course, the consent should be freely given, no? It should be intelligent, or it should be intelligent, it should be free, it should be spontaneous, and it should be real, no? So remember this, no? The consent should be intelligently given, it should be freely given, it should be spontaneously given, and it should be a real consent given. Now the object, of course, will be what we are after in the contract, no? The object, of course, coming from this word, object, will be, it's either the delivery of an object certain, or the rendering of a service, no? We talked about this before. It could be the delivery of an object or the rendering of a service. As to the cause, well, the cause is the why, or the reason why the contract was entered into in the first place, no? Anyway, this is just a review. We will now be discussing about vices of consent here, no? Vices. Okay, I will erase this now. So when we talk of vices of consent, what comes to your mind? Anyone? When we talk of a vice, no? No, vices of consent. What did we say again about consent? No? We said that when you are entering into a contract, of course, the consent should be freely given. It should be intelligently given. It should be is spontaneously given, and of course the consent should be real, true, no? So these are the definition as to how you give your consent to a contract. And of course, here, if it is not freely given, it was not intelligently given, it was not spontaneously given, neither is the consent given as one that is real, then we have what we call the vices. Perhaps there is a vice or vices of consent. Vices of consent. And when we talk of vices of consent, we are talking about the things that will invalidate or that will annul or cancel the consent that is given. No vices. There is a defect in the giving of your consent. Remember that, no? So what are the vices of consent that you know? So these are the vices of the, when we talk of vices, we are talking about the things that will invalidate or that will make your consent not valid. Okay, clear? So we talk about these vices of consent. No? Of course, your code here will be, say for instance, one vice would be mistake. No? I will mention them all. Second would be violence. Third would be intimidation. Intimidation, if they threaten you, they intimidated you. Undue influence, no, is another vice of consent. And then the last would be what we call fraud. Okay, we will be discussing this one by one. But if you would like to memorize or you would like to remember the different vices of consent, your code would be MU. No? MU. So that is the way by which you memorize. M would stand for mistake. V would stand for violence. I would stand for intimidation. U would stand for undue influence. And fraud would stand for letter F. Okay? That is how you should memorize so that it will be a lot easier. And this is how we do it in law school. No? We have our own code. Okay, let us take for instance the first vice of consent. The first vice is what we call mistake. No? Undeniably, all of us individuals commit mistakes. No? And when we talk of mistakes, of course, it can be attributable, it can be attributed to us either a mistake in the fact, mistake in fact, mistake in fact, or factual mistake, or mistake in the law. Factual mistake or mistake in the law. No? So here we have two kinds of mistake. A mistake in fact and then a mistake in the law. Okay? But remember that when you committed a mistake in the process of entering into a contract, because we are talking about the vices of consent upon signing or upon entering into a contract or upon consummate or upon perfection of the contract. Now when we talk about mistake, this is one vice which will invalidate your consent. Why? Well, because you made a mistake, invalidate your consent, the consent that you have given. Why? Because any human person can commit a mistake. Diba? Can commit a mistake. What did I say? Mistake in fact, or mistake, or a factual mistake, mistake in the facts or fact, and mistake in the law. No, that is, you committed an error or you made a mistake as to your interpretation about the fact or by the law. Here, when we talk about the mistake in the fact, we are talking about what? The object of the contract, the object. When we're talking about the mistake of the law, we are talking about the mistake in the interpretation or making conclusions as to the law that will be applicable. Okay? So, every individual is susceptible to committing mistakes. Now, if you made a mistake upon signing the contract or upon entering into a contract, that may cause, no, an invalidation of what you have entered into, because mistake is a vice. One of the things that will invalidate your contract. Because as you can see, consent is very essential. Consent is one of the essential requisites of a valid contract. Okay, so this is the first vice of consent. The second vice, of course, is letter V, no? Because M, view. Letter V would stand for violence, no? So this is the second vice now, violence. So when we talk of violence, of course, violence would involve a physical harm, no? Physical harm. If you have given your consent to a contract because you were forced upon, and that violence is serious and irresistible, no? So, umakto ka, you signed the contract or you accepted the contract, but you were just forced because you were being harmed by the other party or whoever party that is, and that harm that is inflicted upon you is serious or irresistible, then that will also invalidate your consent. So here, of course, when you were just forced upon, no, by any party for that matter to enter into a contract that might have resulted in giving your consent, then that will also invalidate your consent, the giving of your consent. And being invalidated, of course, there is no consent that we can speak of. No, you did not give your consent freely, spontaneously, real. Your consent is not real. Your consent is not intelligently given. Okay, clear? So that this is another vice of consent. The third vice of consent, MU, is what we call intimidation. No? So that is another vice of consent, intimidation. Now, intimidation, of course, if the other one, so for instance, if violence, there is physical harm. This one, what we have here is a mental harm. No? Mental harm. So you were being tortured mentally. No? So if violence would involve physical harm, this time it would be a mental harm. No? They are inflicting mental harm to you. That's why you entered or you signed the contract. And this intimidation should also be serious. No? So the intimidation that is inflicted is serious and also evident. Evident meaning kitang-kita. No? Evident would be meaning it is obvious. No? Now, if you entered into a contract, you have given your consent to a contract, but you were intimidated by somebody else for whatever reason, they caused you mental harm. No? Say for instance, okay, you signed this contract already, you enter into this contract, but remember, no, there is intimidation, meaning what kind of harm is that? It is serious, evident. Example would be, for instance, example of a mental harm would be, say for instance, a mental harm would be just like what you see in the internet, like, say, instance, they will say to you that, okay, you just signed this contract and we will not be showing anymore your, say for instance, pictures that are obscene, no? Pictures that are obscene. Of course, that one will cause you mental harm, no? Imagine that you will be thinking a lot about the effect or the cause if they have shown you shown your picture to the public, obscene pictures and that, of course, that will cause you mental harm. If that is the reason why you entered into a contract, they have caused you a mental harm, then it is as if there is no consent at all, because this is also a vice of consent. You did not give your consent freely, intelligently, spontaneously, and your consent is not real or real. Okay? What is the fourth vice of consent? Well, undue influence. No? Number 4 is undue influence. No? So the term here is undue influence. There is an influence by who? Well, by could be somebody else, no? But the influence given is undue. Now, because we are talking about influence, we talk about one who is more powerful. One of the parties is more powerful and the other is weak. No? No? So here, the one that will inflict undue influence will be the more powerful, taking advantage of the weak. Right? So if you sign the contract because you were just forced upon, or you were just what do you call this? You were just you subscribe to agree to the contract because you were forced upon by somebody more powerful than you are, and you are afraid of the consequences of your own action, then they are taking advantage of your weakness, no, of your weakness, and that is considered as undue influence. Now, if this happens, you gave your consent because you were influenced by somebody who is more powerful, and you are afraid of the consequences if you do not sign the contract, then it is as if you did not give at all your consent also to the contract, and that is also a vice of consent. No? And the last one, of course, which is very common, is, of course, fraud. No? That's the last vice of consent. Fraud would be also a vice of consent. Kasi when we talk of fraud, there is a concealment, no? Concealment of material or important information, no? Info. So if they did not disclose the information that are material or important, and you were made to believe that that is actually the situation or the scenario, then it is as if you have been misled, and you did not actually give your consent freely, intelligently, spontaneously, and real. No? So here when we talk of fraud, sometimes some parties would use schemes, no? They would use schemes or what we call machinations, no? Machinations. No? What are schemes or machinations? And of course, they also use insidious words. Insidious words, meaning the intention of the party, the other party, or any other party, third person for that matter, the intention, of course, is to deceive the other party. And if you were made to believe about the representations, the false representations, or because of these schemes you were made to believe, to accept or to agree to the contract, then it is as if consent was not freely given. So that will also invalidate your consent. What am I driving up here or driving at here? Now, of course, consent is an essential requisite for you to be able to enter into a valid contract. No? Consent is very essential. It's one of the 3 essential requisites for a valid contract. Now, if this consent was not freely given, was not intelligently given, was not spontaneously given, or was not real, no? All of these are absent, because of the presence of the vices of consent, then it is as if consent was not given. And lacking of consent, one of the essential requisites is lacking, then that will also invalidate your contract, no? The contract that you have entered into. Then finally, my discussion, so that we will be through with obligations and contracts. We will be leaving this topic already, but this is also a part of your preliminary examination. We now discuss about defective contracts. No? Defective contracts. No? These are defective contracts. And being defective as such, there is, when we talk of defective contracts, of course, they lack one of the essential requisites, no? The three essential requisites. Defective because they do not conform, not in conformity with the essential requisites, no? With the essential requisites, no? Okay, there are only three, no? Three. One would be the consent, two would be the object certain, and third would be what we call the cause, no? All of this should be present in order for the contract to be valid. Missing one, say for instance, if this is missing or any of this is missing, then we have a defective contract. Now, what are the defective contracts? This was your assignment last time, no? So we have what we call, the first would be rescissible contracts, no? Rescissible contracts. Second would be voidable contracts. Then the third would be unenforceable contracts. Unenforceable contracts. And the fourth would be what we call void contracts. No? Let us discuss this. No, void, not valid at all. When we talk of a void contract, not valid, and not being valid, it confers no rights. No? Confers no legal rights. When we have a void contract, no, this is void. No? When it is void, it is not a valid contract. Therefore, not being valid, it does not confer any right at all. So, wala. No? In short, wala. So we just concentrate now for these three defective contracts in order for us to understand more clearly. Okay, we go to this rescissible contracts. When we talk of rescissible, it can be rescinded, no? Rescind. What do you understand by rescind? Well, it could be what? Set aside, no? Set aside because it lacks one of the essential requisites, or it can be cancelled, no? The term there is cancelled or set aside. This is the meaning of what we call rescind. Why is it that when do we consider a contract rescissible? Well, it can be rescinded, or it is a rescissible contract when there is what? There is an economic damage or injury. Economic damage or injury to one of the contracting parties, to one of the parties, no? When we talk of an economic damage or injury, we are referring to a lesion, no? This is a legal term, no? Remember, lesion is economic damage or injury. Remember this, no? There is an economic damage or injury to one of the contracting parties, no? So example of this rescissible contract, an example of this is, say for instance, by the way, that economic damage, no? Because we're talking about rescissible contracts, or that economic damage or injury What is the other term for economic damage or injury again? We call that lesion. No? Lesion. No? This is a legal term. No? The economic damage should exceed about more than 1/4 of the value of the property. More than 1/4. No? If one of the parties suffered more than 1/4 economic damage or injury over that property, then there is lesion and it is subject to rescission, or what we call, it can be rescinded, it can be cancelled or set aside. No? That is rescissible contract, which is a defective contract. No? Now, example for instance is the contract entered into by, say for instance, somebody representing a ward or a minor. Say for instance, the minor has a property and the agent, no, the agent or the guardian, for instance, no, the guardian of the ward or the minor entered into a contract with somebody else, no, entering into a contract where there was economic damage, no. Say for instance, economic damage or injury. Say for instance, the price agreed upon is quite low, and this economic damage or injury is more than 1/4 of the total value of the property. Lesion. This is the lesion. No, the injury is more than 1/4. Of course, it can be rescinded. No, get the point? Because there is an economic damage or injury to the minor or the ward. That is just an example of rescissible contracts. Another example would be, say for instance, if you sold, no? If supposing you sold properties of a debtor, no? Of a debtor, being an agent, no? If you were the agent of a debtor and you sold properties which cause economic damage or injury also to the creditors, no? Because the creditors will run after the debtor, no? If they could not get any more property from the debtor because you sold everything, then the contract that you entered into with other parties will now be subject to rescission, no? Clear? I repeat, this one is an example, no? If you were the agent of a debtor, and of course the debtor has properties, and you sold his properties to the prejudice of his creditors, because the creditors are interested with the properties of the debtor, right? If you sold everything and the debtors could not collect anymore, and this has caused more than 1/4 of the total value of the properties of the debtor, or for what the creditors could collect, then it is subject to rescission, or it is a rescissible contract. Okay, clear? Next, after rescissible would be what we call voidable contract. So this is the second defective contract, voidable contracts, no? So voidable contracts are actually valid contracts. These are valid until annulled, no? Until annulled. So from the very beginning, from the beginning, these kinds of contracts are valid. It's just that there is a defect in this contract. Where does the defect lie? No? Where does the defect lie? Because of, these are the reasons why there is a defect. Lack of legal capacity to enter into a contract. No? Lack of legal capacity to enter into a contract. And the other one is, of course, the vices of consent, which is MU. No? So where is the defect here? The defect on the giving of consent. No? Because you see, you entered into a contract, but the contract was not valid, can be voided, rather, it can be annulled because you lack this, yung MBUF, yung consent that should be freely given, or you lack the legal capacity, then it can be subject to an annulment, these voidable contracts. I repeat, when you enter into a contract, there should be consent. And that consent should be freely, intelligently, spontaneously, and real. No? The consent given should be intelligently, freely, spontaneously, and should be real. There should be no vice of consent at all, yung MU. Neither should there be a lack of legal capacity. Now, even if this, you know that this, you lack this, and then you entered into a contract, well, it can be annulled because those contracts are voidable. Okay? The third now is what we call unenforceable. Now, I will not discuss anymore about void contracts because void contracts do not confer any rights at all, and wala at all. No? The third would be what we call unenforceable. Unenforceable contracts. Now, when we talk of unenforceable contracts, when we talk about these contracts, we are talking about cannot be enforced in court. Cannot be enforced, meaning it cannot be presented as evidence. Cannot be presented as evidence. Now, why do you think that these contracts are unenforceable? What are the reasons why we have unenforceable contracts? Well, they were entered into without what? No authority. Without or in excess or of authority. Meaning, you are not even the agent of the owner of the property, and yet you entered into a contract. You have no authority at all. So without or in excess of authority, then that is an enforceable contract. Second is you have to follow what we call the statute of frauds. No? What is the statute of frauds? No? The statute of frauds would state that there are contracts that should be in writing. No? Say for instance, a contract that requires the compliance with the statute of frauds is when you are selling real property. No? It has to be in writing. No? Otherwise, if you sold real property and you did it orally, then you are violating the principle or the rules of the statute of fraud. So that is not valid. It becomes an enforceable contract. And the third is both parties do not have legal capacity. Both parties do not have legal capacity. No? Meaning, could be that both parties are minors, no? Or incapacitated, for instance. And then they both entered into a contract. Of course, that will be an enforceable contract. So I repeat, the reasons why we have an enforceable contract: there is without or in excess of authority, there is a violation of the requirements of the statute of frauds, and then both parties do not possess any legal capacity. Okay? In short, again, there is the vice of consent. No? Consent is very, very important. Okay, I think that is all for today. But these ones are included in your preliminary examination, so you review. And also the assignments I have given you before. How many assignments? All in all, I think there are already 6. Also the assignments up to assignment number 7 rather. So assignment number 7, 1, 2, 3, 4, 5, 6, 7, those assignments are also included in your preliminary examination. So good luck And I will see you on October 27 during your preliminary exam. Okay, thank you and good afternoon.